Charles C Ltd and the Secretary of State for Energy Security and Net Zero.
Thank you. Yes, Mr. Wolfe.
Good morning, my Lord. Can I take you next, if I may, to tab 18 in the legal materials bundle?
Yes.
Which is Preston New Road Action Group case.
Yes.
Relied on for a proposition relating to hypotheticals, that's
yes.
the word used. In a sense, the factor, the critical point here, we're dealing with a proposal for exploratory works which may or may not, and that's the crucial thing, in the future lead to a fracking scheme. Page 369 of the Courts bundle, above para 57, the heading is Issues 1, 2 and 3, Lawfulness of the EIA Assessment.
Yes.
In my Lord's judgment, para 59, the Lord sets out Mr Frackman's submission, and the crucial thing is about 9 lines down. Their complaint is about the lack of assessment as part of the assessment of this scheme of the future exploration. The crucial words are, if the exploration phase proved the existence of a viable resource. It's about 8 or 9 lines down in paragraph 59.
Yes.
And then similarly, over the page 463 in the internal pagination in paragraph 60, picking up the frack-free Rydale, which had a similar point, again about 7 or 8 lines down towards the end of the line, any further gas extraction, that was the critical thing. And then that's pulled together, paragraph 68.
Yeah.
My Lord refers to the Brown and Carlisle City Council decision, we saw that yesterday.
Yes.
And then about 5 lines up from the bottom of 69, it's another future project which might never happen. And that's what then feeds in at paragraph 75, about, again, 6 or 7 lines from the bottom towards the end of the line. One comes back to the same basic point. If in the future a project emerges for the commercial production of shale gas on the 2 sites, it can only properly be subject to assessment under the regime when it comes to be promoted as a real, not merely hypothetical proposal. Yeah. So that's very clear and very straightforward. That word hypothetical was then used by the judge to describe options here, including, for example, the permanent desalination plant. They're hypothetical only in the sense that we don't know which one of them is going to go forward. Whereas in the fracking examples, it may be that they did their exploratory works, found no relevant minerals, and went away.
Yeah. So this was don't know which rather than don't know whether.
Exactly. Then we have an Ashchurch decision of this court. We have in tab 25.
Yes.
Stark facts, but the principles we say are nonetheless clear. And indeed, in one sense, my lady's judgment makes clear that the primary failure here was the problem the local authority were here dealing with ground 3 of their of the decision, which is relating to its environmental impact assessment. The fundamental problem here was that the local authority hadn't even asked itself the question. But the court nonetheless went on to look at some of the principles that would have underpinned that issue, in part because the judge looked at some of the issues, the question that would have underpinned that issue. Of course, in this instance, the first in-time project was a bridge, which had relatively low impact but absolutely no use. And the benefits would come from the second in-time project, which was the development in the land beyond which the bridge was going to unlock. So, in that sense, greater harms down the track. This is an EIA case, not an HRA case, of course. But nonetheless, 2 fundamentally linked projects. And it's that linkage which is critical here. Within that, simply to just identify some, what we say are points of principle, ground 3, page 692 of this court's bundle.
392.
392 is the beginning of my lady's judgment. Sorry, 692 did I say?
692. Sorry, I misheard. No, I misheard.
Completely mine. 692, I'm grateful. Ground 3. This, of course, was decided after our present case had been commenced. Paragraph 78, I want to highlight on some points of principle, the identity of the project for these purposes is not necessarily circumscribed by the ambit of the specific application. And then paragraph 88, page 695.
Yeah.
Again, similar point, rejecting the proposition that something couldn't be part of, something that's down the track couldn't be part of the project now, because there hadn't been an application. Then at 90,
Yeah.
rejecting the proposition, this is halfway down paragraph 90, the difficulty of carrying out any assessment of the impact of a larger project which is lacking in detail is a matter which is separate from and irrelevant to the question of whether the application under consideration forms an integral part of that larger project. So it may go to the amount of detail that you have for your assessment, but it can't, as a matter of principle, go to the question of whether it's part of the project or not. Similar in 92, the phase 1 project may not be easy to define. Phase 1 project, slightly tantalising here, is actually the second in time project. May not be easy to define in detail because it's at a relatively early stage, which explains why the screening report refers to a lack of definition. That may affect the way in which the overall assessment of whether there is a significant impact of the environment is carried out. It would necessarily be based on less concrete information than an assessment at a later stage of the planning process. However, in my judgment, it cannot affect the answer to the initial question at the screening stage: is this an application part of a larger project? Then at 101, two points in 101. In para 119, that's of the judgment, he appears to have regarded it as conclusive for the purpose of 2017 regulations that the application was simply for the bridge and not for the totality of the relevant development. Insofar as he did so, he erred in law. That would be true in any salami slicing case. So just pausing for a second there, the judge makes a point where he says the Secretary of State was entitled to take into account the fact that this was only an application for a for a power station. I'm not sure the Secretary of State actually made that point, but the judge took him as making it. Anyway, in the judge's analysis, if not in the Secretary of State's analysis, it would be a bad point. And then, the second point in 101, moreover, in paragraph 120, he, that's the judge, appeared to consider that the lack of any intention to salami slice was conclusive of the question of whether considering the bridge in isolation would be tantamount to salami slicing. As I made clear yesterday, we're not talking about salami slicing here in that sense, but what that very clearly says, and we say correctly, is that it's not about intention, it's not about any ill motives or whatever you want to say in trying to circumscribe the process. It's about the effect.
Yes.
Well, Lord, what I'd then like to do, if I may, is ask you to bring to hand our skeleton argument for this court,
Yeah.
and the judge's judgment, if you want.
Yes. Just a second. You would?
And I'm not, as I canvassed yesterday, I'm not going to take you through every element of this. You've got it. You've got our grounds of appeal, which make a series of points about the judge's judgment, and the skeleton very much in a slightly different order, but picks up all of those points and elaborates on them slightly.
Yes.
So this is more by way of a signposting exercise, if I may. Under ground one, which we start at paragraph 47, that's page 611 if you're using a paginated version. We say in paragraph 50, and the point is also made in 53 to some extent, that the judge rejected the appellant's argument on the incorrect premise that the Habitats Directive does not require assessment at the earliest possible stage, etc. And then a similar point is made in our 53. And we draw the court's attention there to the Court of Justice decision in Inter-Environment Wallonie,
Which is the paragraph of the judge's judgment where you say he erroneously...
I'm sorry,
Which is the paragraph of the judgment where you say the judge erroneously rejected it?
it's paragraph 81 of the judgment. We say that in our 53 of our skeleton, I hope, signposts the court to that. That point needs a little bit of illumination, which I'm about to do, if I may.
Can we just check what he did say there?
He did. Well, that's why I'm going to come back to illuminate it, because there's a bit more in the paragraph that I need to pick up.
So you're going to take us to what the judge said?
I am. Can I take you to inter-environment first, if I
yes,
may?
Of course.
That's in tab 20 of the legal material.
Yeah.
At page 485 of the court's bundle. Sorry, 484. That paragraph earlier. Paragraph 140. Heading is when the assessment should take place. And I think on reflection there are two ideas floating around in here, and I just need to tease the two ideas out. The second sentence of Article 6.3 of the Habitats Directive specifies that following an appropriate assessment, the competent national authorities are to agree to the project only after having ascertained that it will not, etc. 141, it follows that the assessment must be conducted before the agreement is given. Right? And that's the critical bit that bounds this. I'll come back to in a second. Furthermore, while the Habitats Directive does not define the conditions governing how the authorities agree to a given project, the EIA Directive is relevant. 143, accordingly, by analogy with the court's finding on the EIA Directive, if national law provides for a number of steps in the consent procedure, the assessment under Article 6.3 should in principle be carried out as soon as the effects of the project in question is likely to have a protected site are sufficiently identifiable. So there is the, as it were, I'm going to call it an urgency, a timing point. But the timing point, and if I can then take you back to the judge's judgment, which is paragraph 81,
right.
The timing point, he's wrong to say there isn't a requirement to do it as soon as possible.
Can I just read paragraph 81 for a moment, please, just to see the context. The claim to just give me a moment, please.
So my lord, looking at paragraph 81 in the judgment. So to go to 81 in the judgment, what I've just shown you in relation to inter-environment baloney is dealing with the first part of that paragraph, when the judge says there is no objective in the Habitats Directive requiring appropriate assessment at the earliest possible stage. Yes, there is, but that's not at the end of the point. Instead, the judge says, the directive focuses on the end result of avoiding damage to a European site. In the case of a multi-stage consent or a multi-consent, it may be subsequent rather than the first consent which authorises the implementation of the project. So there's an imperative to do it early, but not a determinative one, if you like. It may be possible to leave it later in a multi-staged project. And that then references, as it happens, the authorities which Mr Strawn so helpfully handed up yesterday. So you may have a multi-stage project, and in our system that might be an outline planning permission followed by a detailed planning permission followed by some conditions, for example. So there might be a multi-stage process. But the critical thing is, insofar as you push that assessment down the sequence, if you like, because you say you can't do it early, which is in some circumstances permissible, you have to do it before you grant the ultimate consent that allows the project to go ahead. And that's what Mr Justice Holgate is summarising in 81, if you like, correctly. And if we then pick up...
So the mistake you say he made in 81 is in the second sentence?
Yes.
When he said there is no objective, when he's adopting what Mrs Justice Lang had said in Wingfield.
Yes.
And he distills that as there is no objective in the Habitats Directive requiring appropriate assessment at the earliest possible stage.
And inter-environment shows that's not entirely the case. it recognises that impacts may not be sufficiently identifiable, but that's at the earlier stages of a multi-stage consent process. That's the important thing.
Yes, but the substantial point is that the what is being considered has to be sufficiently identifiable.
Yes.
That's a fair characterisation.
That's a fair characterisation, but you don't take that as an abstract proposition.
No.
You see that within the context of the multi-stage consent regime.
Yeah.
So you might not, at your outline consent stage, assess something, right? You might say, we're going to do that at the detailed consent stage. Or you might say, I'm going to do it when I come to discharge a condition. The directive, inter-environment, would encourage you to do it earlier, so there is that imperative, but the point is you have to do it before the final stage. You can't postpone it beyond the final stage, and that's,
it has to be done. It has to be done within the timescale that encompasses the decision making, so that nothing is permitted without an appropriate assessment. I use that in a small a sense.
I think correctly.
But correctly, as it turns out. That's the substantive ambition and requirement, actually.
Yes. And if, of the cases that Mr. Strawn handed up yesterday, actually it's Mrs. Justice Lang in the Wingfield No. 2 case who deals with this most fully. He's helpfully sidelined the passages.
I mean, do we need to look at what Mrs. Justice Lang actually did say in those 8 paragraphs?
Well, I was going to draw your attention. Ms. Grogan's helpfully sidelined the passages. Right. I think it's paragraph 74 in the Wingfield.
So we're going to that. We're going to that now. Wait, can you give me a page reference?
Did it end up in a page reference? It's a loose one, I think. It's.
This is the second Wingfield.
It's the second Wingfield.
Right. I put these in at the front of the bundle. Yeah. So 74.
74.
Yeah. Yes.
So just to put that into position here, whether you look at this through the prism of saying this is all one project, or you look at it through the prism of cumulative assessment, the problem here is that the assessment of the totality of what is required to make the power station work, I'm trying to choose separate words, is not going to be assessed until either the permanent desalination plant or Northumberland Water, do their exercise down the track. The difficulty with that is that by that stage, the power station will already have been granted permission, as we've discussed, has been granted permission. And whilst in theory, the water supply could be refused at that point, in practice, it's overwhelmingly incredible that it would be. And indeed, the Secretary of State's decision on the power station assumes that consent will be granted because he's confident that it can be and will be. And so then, going back to the exchange we had yesterday, by that point, the power station will have been granted consent without having had a full assessment of its impacts in circumstances where the necessary implication of the examining authority's analysis is that that might have made a difference. And that's set out in our the skeleton we're looking at. Those twin concerns are set out in paragraph 74.
Paragraph 74 of your skeleton.
About our skeleton.
Are we putting Wingfield away?
We put Wingfield away, yes.
Just a second, I need to get back to your skeleton argument. Paragraph 74.
74, which it's part of the, it's been labelled the foot in the door dialogue. So 74 deals with 2 points arising from this sequencing. First 6 lines dealing with the inevitability of the water supply. Second part dealing with the fact that the power station would then have been, sorry, it's the other way around. I'm reading it all the way around. First part dealing with the power station having been assessed without its impacts in circumstances where that might have been made a difference, the tipping the balance, and the second dealing with the inevitability of the water supply.
But just help me with one thing. If they're separate projects, and ground 1, which is what I thought we were dealing with, and if they're separate projects, then the fact that a separate project is assessed before that separate project is granted consent is one thing. And you can't say if they're separate projects, actually, can you, if they're right to say, or if they're entitled to say, that the power plant is one project, they will have granted permission after an assessment of that project. Then, on this hypothesis, the water supply is a second project. Now, you've got one set of arguments about will you grant permission for the water supply, even if it has an adverse effect, because you feel compelled to do so because of the plant, and that's one set of arguments. But how logically can you say you can't grant permission for project 1, which is separate, on this hypothesis, until you have consent for project 2?
Well, it was, first of all, the analysis in my submission goes to show that it's actually should be treated as part of the same project.
Yes, that's right.
But even if that weren't the case, then it inevitably, we say, falls into part of the cumulative assessment calculation. And via the cumulative assessment calculation, it's then taken into account.
That'd be a separate thing, because what you're doing cumulative assessment for there is for the second project. Once it's a second project, you're saying, should we grant permission for the second project, the water supply? Is there an adverse effect? If so, is there economic overriding reasons? If so, will I use the power plant as part of that? That's to do with the second project. But concentrate first on the first purpose, the first question, which is the project. If the first question is, are they separate projects? And the answer is, no, they're not, then you're fine, you succeed. If the answer is they are separate projects, then I don't quite understand on the ground 1 issue how you must get permission for a second project before you grant permission for a first and separate.
Sorry, it arises on ground 2. It's a ground 2 point, and that may be where we're not at cross purposes.
But I thought 74 was ground 1.
No, it's in 74 is in
ground 2. We're not to ground 2.
No, I'm just picking up the thread of the habitats point, if I may.
Yeah, I'm getting lost because we looked at ground 1 with Mr Justice Holgate, and you're saying his view of ground 1 was wrong, which I thought was a separate project. You've then gone into paragraph 74 of your skeleton, which is also under heading ground 1. So I thought we were dealing with ground 1, but paragraph 74 is also relevant, you say, to the next ground 2.
74 in the skeleton is in the ground 2 section. Sorry, I'm sorry if I'm confusing the court.
Oh yes, it is. Yeah, sorry.
The point is, if this were a multi-stage consent process where you didn't get the green light till the very end, you could delay the assessment down that track if you needed to. No debate about that. The issue here is you have two separate activities, and we say the linkage between the two, first of all, means that they are a project, but even if they're not a project, means that the impacts of number 2 have to be assessed before you give consent for number 1.
Yeah, but that is ground 2, isn't it?
It is, my lord. It is, my lord. Yes.
I just wanted to come back. I hope I'm not cutting across your answer to my lord, but I want to come back to the proposition which was that it was overwhelmingly improbable that permission would be refused for the water supply project. It brought back to mind a passage in one of the judgments of Lord Justice Sales, as he then was, either, I think, in Lark Fleet or Forest of Dean, in which, and it may be a different context, in which he said that the the fact of the permission having been granted for the first project created, I'm not sure what he said exactly.
It's Forest of Dean.
No presumption whatsoever, or some such formulation, that the second project would be permitted. Do you remember the
I
passage?
do, exactly. It's in Forest of Dean.
Do you mind if we just look at that again?
Of course. And that's why I spent some time on the facts of that case.
You did, yes.
Because it's absolutely fundamental to understanding this point. It's tab 14.
So, yeah, let's look at that.
And the two.
Yeah.
Did I say 14?
You did. That's Forest of Dean.
Yes. The two critical distinctions, factually, between that case and this case, are this. Distinction 1, remember that was the one where you built 2 developments and the spine road came later.
That's right.
Distinction 1 is no requirement for the link road. It was the question my lady asked me. Sure, they need access, and they've got access. They don't need the link road.
Right.
So so they can get their permission, they can be developed, they can be occupied, everybody's happy. Then the link road comes along, and it either gets its permission or not, but that doesn't have any impact on the previous. So that's a critical distinction between that situation and our situation.
Right.
And the second critical distinction, and it's less critical to the analysis, but key to Lord Justice Sales, is that in that instance, the 2 initial developments, weren't going to be the thing that impacted on the bats, which was the SAC protected species.
So the first project would not impact on the bats?
There was no habitats failure, I use the word perhaps ill-advisedly, in relation to the bats. So what was being said by Miss Wigley was, she was complaining that leaving the habitats assessment to the assessment of the spine road meant that you'd only look at the in-combination effect of the bats of all of those 3 developments at the second stage. Lord Justice Sales says, no problem, because at that second stage, you can still refuse, it's paragraph 13, and then paragraph 19.
I'm looking at 19, which I think is the passage that I had in mind.
That's right, my lord. My lord's exactly right.
The grant of permissions for the 2 sites creates no presumption and adds no force whatever to any contention that planning permission should be granted for the spine road.
Right.
You say that's because of the absence of the link between them.
Exactly right.
But it's a matter of principle, isn't it? Just because you've got permission for one project, that doesn't tell you anything about permission for the second project.
No, it doesn't tell you. It's well, matter of principle. But when we get to project number 2, planning permission is made for some sort of water supply. Let's say it's the permanent desalination plant. Permanent desalination plant will be on the Minsmere SAC. Would have significant impacts on the SAC. NRW sites all potentially equally have different impacts on SACs because that's the nature of this part of the country. So they stumble at step 1 of the habitats assessment. So they drop into Regulation 64. There's then a question about alternatives. If there's a less habitat impactful alternative, it would have to be preferred at that stage. But if what you're offering is the least worst, the least habitat impactful alternative, then you can still get your consent, notwithstanding the habitat's impact, for EROPI, reasons of overriding public importance. And that's where the existence of the power station project would become absolutely overwhelming.
Now, that is squarely ground 2, as I understand.
Yes.
So, no, I just want to
Yes,
get the division. We're focusing at the moment, and it's maybe my fault for taking us in the direction of Forest of Dean again, but we're focusing at the moment on the question, I say the simple question, it's not necessarily simple in its resolution, but simple to state, whether or not it was unlawful for the Secretary of State to conclude that these were 2 separate projects. That is the compass of ground 1, I think.
Well, yes,
Rational, I think.
Irrational. Yeah.
Yes, that's right. And I think, can I just tease that out? Because whilst we do, rather like in the Carlisle airport case, we do say that was the only rational conclusion, we actually don't need to go that far. All we would need to say is that he misdirected himself in the way he approached it.
Well, you said yesterday that you put it on the basis of immaterial considerations,
yes.
which are the factors that
Yes,
emanate
yeah.
from Wingfield.
Yes.
Yeah.
And I'll come back to that in a moment.
In shorthand.
Yes. Yes. But I'm just making the point. We don't need to convince the court that there's only one answer. We just need to convince the court that Secretary of State took a legally flawed approach in asking the question.
But the real thrust of the argument you're answering questions about now falls under ground 2.
Yes, it does. Yes, it does, in the sense that the sequencing point only arises if you've, as a matter of law, decided to have 2 separate projects and you've embarked on that course.
For your ground 2 to work, we have to accept the proposition that because of the factors that you have referred to just now, there was going to be, in effect, a presumption that permission would be granted. A presumption that wouldn't have been there otherwise for the water supply project to be consented.
My lord, yes, but that's not the if you like, that's not the real vice. That is a vice, and that's why paragraph 74 has got 2 components to it. The bigger vice, this is not an argument about granting consent for a water supply in Suffolk in the abstract.
No.
This is an argument about the grant of consent for the power station. And that's why the first part of 74 is
No, of course. No, that's understood. That's why. But it depends on that presumption being present, doesn't it? I mean,
not necessarily. Not necessarily. No. It doesn't. The consent for the water supply wouldn't need to be, let me put it this way, only granted because of the overbearing of the overshadowing by the half-built power station. Even if that wasn't the approach to deciding the consent for the power station, you still have the other problem, which is described in paragraph 74, first part, and elsewhere as well, and a skeleton argument in the court below sets it out a bit more fully, which is that the grant of consent for the power station would have been given, is now under challenge, in circumstances where not all of the impacts of it cumulatively, with all the things on which it depends, were assessed at the time.
That's the problem that I've got. You're not looking just at, on this hypothesis, the project, which is the power plant. You are necessarily saying, before you grant permission to the power plant, you must take account those things where there is some degree of interconnection. I think on this, no matter how you put it, you are saying you can't grant permission for a project because there are things which, on this hypothesis, are not part of the project, but which you say are sufficiently interlinked to mean you shouldn't go ahead.
But I don't want to take it too far. I don't want to take it too far because the facts here are critical. The situation here is critical, which is in step 1, the examining authority took the view that this was potentially an issue which could tip the planning balance. And step 2, nobody is saying that those impacts in the future, version of step 1 wouldn't contribute to tipping the balance, or aren't significant in some other way. So this is, I'm conscious, I'm not sure what's behind my lord's question, but this is not an argument that says you have to assess the impacts of all the things on which this depends. That's the floodgates argument that Mr Justice Holgate was worried about.
Yes, but, I think, is my response for the moment. Yes, but this is a challenge to the development consent for the power station, and that is what is under attack in these proceedings. This is not a challenge to a planning permission or development consent for water supply as such.
No.
And therefore...
Well, not independently.
No, because we're at that stage.
Yeah.
You're challenging the grant of development consent for the power station on the basis that ... everything we've been describing in our exchange.
But it doesn't depend...
It
doesn't depend on stage 2 being
so
overborne.
my Lord's question has that degree of force, doesn't it, to it? Because effectively you are saying that it was unlawful to grant development consent for the first project in consequence of the analysis which you urge us to accept, which is what I'll call the presumption analysis that would obtain at stage 2.
So I don't think, can I be very clear? I don't need the presumption analysis for stage 2. Right? All I need is that the examining authority implicitly took the view that the impacts that might come forward at stage 2 might tip the balance at stage 1. And that's why the ordinary housing development, which is connected to water main, doesn't come anywhere close to this.
So does it boil down to this, that if it is considered that something in relation to a completely separate project might, if it were taken into consideration on project number 1, tip the planning balance, it must be taken into account?
At the stage of granting permission.
At the stage of granting permission for project 1.
If and then there's a bit missing with respect to my lady's analysis, which is that project 1 can only go ahead if project 2 happens. It's dependent upon project 2. That's the critical interaction. It's not because otherwise you're just talking about the ordinary assessment of cumulative impacts, which is not this case. Exactly. You don't say, well, if I took into account along with my project 50 other projects in the neighbourhood, that might be bad. No,
well,
don't do that, because 50 other projects in the neighbourhood are entirely independent. That's jolly old Larkfleet and all the rest of it. And that's going back to Lord Justice Sales in what is actually Larkfleet, paragraphs 36, 37, 38. He precisely says that the concerns about things dropping out of the project that are linked, or necessarily linked, is dealt with through the cumulative assessment process.
Then why isn't the answer, if this is a question of rationality, the Secretary of State taking a different view from the examining authority, why isn't the Secretary of State, assuming it's rational, entitled to say, well, actually, I think what's likely to happen is a water supply, which at worst is going to have environmental impacts on a European site separate from the site of the project, the power plant, because it starts at one end of Suffolk and comes a pipeline that might go through another birthplace. And I think that is what is likely to happen. And I think the effect on the European site of that pipeline or that water supply delivery mechanism or whatever they do is the thing that's likely to happen. And therefore, since I'm reasonably confident that that's going to happen, then what I'll be looking at is that. To go ahead with the project and not require the first project to wait until the second project has crystallised and you know where the line is going to go or whether or not it is indeed going to be the default option. If it's rationality, where's the irrationality in the Secretary of State saying on the information before me, I'm not going to do that?
If the Secretary of State had done what my Lord had just said, I wouldn't be standing here. That's the point. The Secretary of State did not do that.
Oh.
No, he absolutely did not take a view on the if he did, and that's there's a passage in the Lord's in the Judge's judgment where he says I've raised a Rochdale envelope question and he dismisses it for various reasons, and in a sense that's the same discussion that you and I are now, my Lord and I are now having, which is if the Secretary of State had said I don't know which one of these options it's going to be, permanent desalination plant, NRW option 1 or 2, whatever it may be. And bear in mind that the pipeline, the 28-kilometre pipeline, is only the pipeline. It's not the impacts of abstracting the water as well. He hasn't taken a view, and we say that could have been done but wasn't, hasn't taken a view on the impacts of that, and then said, given that quantum of impact, I think that the planning balance is still made out of the power station. And just to be clear, that any option would have an impact on the SACs by Sizewell because they all involve works at Sizewell. They may involve permanent desalination plant on the Minsmere SAC, they may involve the pipeline at the Minsmere SAC, but they all involve works there and then potentially other SACs around that part of Suffolk. But the critical thing is the Secretary of State didn't do that exercise. He left that entirely for the future. That's the problem. If he'd said, I can make an estimate of those impacts, that would have been the cumulative impact assessment evaluation that we are complaining about the lack of. It's a bit like in the Bridge to Nowhere case. Court took the view that you could do an assessment of the impacts of the development. It may not be.
The difficulty is that in this case you couldn't do an assessment of the impacts of the development because you didn't even know what the development was going to be.
That brings me back to, I think, the second big issue of principle, which is about the permanent desalination plant. And we did canvass this to some extent yesterday, because there's a big question here. Can a developer make an application for a DCO and say, I have this big problem that I need to solve. I have several ways of solving it, but I'm not going to commit to any of them. I'm confident that one of them can be made to work, but I'm not going to commit to any of them. Because I'm not going to commit to any of them, I'm not going to assess any of them.
That's not quite this position. The position is that they think and hope and believe that a separate body, which has got separate statutory duties, will provide a solution. But if all else fails, they've got something within their control that they think would work.
But the separate body point doesn't take it outside the cumulative assessment, in my submission.
No, I understand
But they may. So the developer comes along and says, I've got 3 options. I'm really hopeful it's going to be number 1. I'm optimistic it's going to be number 1, but I can't really assess that. If not number 1, it might be number 2. Really hopeful it would be that, but I can't assess it. Number 3, I can definitely deliver, but I'm not going to assess that because I'm hoping and optimistic it'll be 1 or 2.
And in my submission, number 3 may never come about. It's entirely hypothetical and future that it may or may not form part of the development. And even if you were to treat it, it's certainly not part of the project or the power station at this stage. It can't possibly be.
So I realised in the to and fro yesterday, my lady, I may have confused things slightly. We are not saying in this analysis that they necessarily needed to say we want to include the permanent desalination plant within our project specification. It's about assessment. So what we say needed to happen is the developer says we've got a range of options, we don't know which one, those are not our preferred one, this is not our preferred one, we're optimistic about those. But there is an absolutely doable option in technical terms and land ownership terms on the table. They may not want to do it and so on. The question is, do they need to assess it for the purposes of this exercise? We say they do, just to play through the logic of that, because that way the Secretary of State has a view on the environmental impacts, the habitat impacts of that way of doing this combined activity.
Which may never happen.
It may never happen.
So what's the point of doing it?
Because it ensures that before consent for the planning permission for the power station is granted, the decision maker in this multi-state process takes into account what may be a worst case, we just don't know. But
it may be a best case. It may be a non-case. The point is you're asking them to carry out a totally futile exercise, which has no meaning whatsoever.
Lady, in my submission, it's not futile. And the logic of the Habitats Directive is very, in my submission, quite clear. You need to take into account the total impacts of your project plus the cumulative impacts of those things on which it's dependent, which might change the balance. That's my point. Yep. If one of the ways of doing it is the permanent desalination plant, you need to assess the impacts of that. Otherwise, you've got no assessment at all. If you assess those impacts and still decide to grant consent for the power station, all well and good, you've complied with the Habitats Directive. You, the developer, then comes along, or NRW comes along, NWL comes along in 2 or 5 years' time and says, well, we've got another option. It's habitats impacting case, so it engages Article 63.1. Let's assume, which looks likely, it's going to trigger 63.1, tips you into 64. 64 says, in the absence of alternatives, is there a ROPE? The alternatives at that point would be your assessment. You've got an idea of a permanent desalination plant, which is going to be an alternative at that point anyway. All of these things are going to be alternatives in that analysis at stage 2. At stage 2, you then say, well, actually, the permanent desalination plant is worse than what we're now contemplating in the River Waveney, so we go ahead with the River Waveney. If it turns out the permanent desalination plant, which you have assessed already, is better than what you've got in the River Waveney, you can't grant consent for the River Waveney option. I'm calling it that. But that's how the Habitats Directive works. It's about making sure you have an assessment of the impact of the project with its consequentials before you grant consent.
Yes. But let's just all draw a breath for the moment. What I would like to suggest, if I may, Mr. Wolf, is whilst we've had questions which we've felt compelled to ask to elucidate the argument, I do think it's right that we should let you develop, on reflection in the light of these exchanges, the further points you want to make on either ground. By all means, adopt the signposting approach if you think that's appropriate, or whatever approach you think is right. But I'm very conscious that we've had these exchanges which have been most useful to us. But I do want to ensure that your case, as it were, is fully before us before you sit down.
Can I then come back, if I may, that's helpful, Lord, to come back to this Ascalon argument, just to pick up some key signposts of the judgment. You've got the stuff here set out fairly fully, I think.
Yes.
paragraph 51 and 54 deal with the judge's proposition that the respondent was unable to identify a permanent supply, and then 54 says no option to assess. We say that is simply wrong by reference to the permanent desalination plant. That's 51 and 54. And the consequence of the question, which I've just been canvassing with the court, is, and the developer, so the point we make at 51, if an applicant were able to be unrestrainedly selective in this way, there'd be major gaps in environmental protection. Basically, it would be a massive doorway into that habitats regime. Developers could simply say, we don't want to commit, we're keeping this open, take it outside the assessment. There are then some points, in a sense smaller points, but they're important in the judgment. Paragraph 56, our 56 that is, the judge was wrong to find the first respondent lawfully entitled to take into account not part of the DCO application, and that's just contrary to what the lady said in Ashchurch. Then there's 57, separate ownership, where the judge rewrites the decision. Then there's 58, the no functional interdependence. We simply say there's clear functional interdependence. Then at 63, the wider implications point. Just to remind the court, nobody here said that the water supply couldn't be part of the project. So we're into the territory. So water supplies can be part of a project. So the concern that Mr Justice Holgate had was live in the Secretary of State and the examining authority even canvassing the question. The question is, where do you draw the line? And the flip side of that, we say, the other floodgates concern is the one that I made a moment ago, which is the possibility of, or the reality of developers simply being able to say, well, we're leaving that till later. We're parking that assessment till later. Please give us the consent for our main deal now. 64 really expands, 64 to 66 really expand on that point in more detail. 66, the judge's analysis conclusion, if correct, would have significant implications for wider assessment of projects. The cumulative impact of linked projects, in particular, a developer could simply decline to commit to how part of its project would be implemented to escape assessment of the combined effects. That is absolute Trojan horses through the Habitats Directive. That's underground 1, underground 2. 69 relied mistakenly on the fact the water supply solution was unknown. Well, follow into our paragraph 70 and 71. That's no answer for the reasons I've discussed. I won't go over them in detail again. Then we have in ground 2, long extract from Larkfleet, that's paragraph our 73. Remind the court of paragraphs 36, 37 of Larkfleet. We've looked just now at our 74, which is the twin concerns. Just to remind the court, the concern about under-assessment of the project now is not, doesn't necessarily depend upon the concern about the overbearing at the second stage. And I also just ask the court, we have this in our skeleton argument in the High Court, pages, it's core bundle, page 150, paragraphs 22 and then 40 to 42. Pick up that same point in a little bit more detail. Then at 77, the Forest of Dean point. And then just pick up 78, if I may, what flows from the Forest of Dean point. 78, the necessary implication of the examining authority's overall recommendation, namely that the impact of the water supply element necessitated by the power station, taken with the impact of the power station, could tip the planning balance, was not confronted, let alone disputed by the first respondent in response to the claim. The approach taken by the interested party in keeping its options open, that's not a culpability question, it's not casting any aspersions, and the first respondent in making the DCO on that basis is what creates the foot in the door and thus vitiates compliance with the habitat regulations process. And then just to, you may be exhausted with looking at the Secretary of State's decision, but just to sort of finally, before I sit down, subject to any questions and the poking from behind, within the decision itself, just starts really at page 370 in the core bundle.
So sorry, Mr. Wolf, I missed the number.
370.
Thank you very much.
Thank you.
Yes.
So insofar as we can see where the Secretary of State addressed this project, that's one, it's in 449 and 465.
449 and 465.
I think I'm just being slightly tentative for
Right.
each, see in a minute.
Well, do you want just to check that to make sure it's
So 449 talks about separate projects. It's the only paragraph that uses the language that really leaps out on the page.
Yeah.
Now, it is only talking there. Secretary of State considers the proposed development and the WRMP 24 process are separate projects. Nobody is saying the process is part of the project. We're not claiming that the entirety of the water company's activities is part of the project. Nobody would ever suggest that. But that is dealing with that. We have criticisms of that analysis. They're in the skeleton. I'm not going to take you back to them. The single project point is also implicitly part of 465.
Yeah.
Where the Secretary of State says, disagreeing with Natural England, doesn't agree that the source of any permanent water supply is in itself integral to the application. So it doesn't use the language of single project, but that's the point they were making with which he's disagreeing. His answer to that is 5 or 6 lines down, no current certainty. And then last bit of the paragraph on the page, the Secretary of State agrees with the position of the applicant, assessment of implications of permanent water supply will be undertaken, and that will take into account any effects. And that creates the habitats problem, which you've seen it mostly in relation to ground 2. Here, impacts on ground 1. But none of that is picking up the permanent desalination plant, which the Secretary of State deals with. So not put under the heading of project, but I'm going to read the whole thing as a whole. I'm not going to read it with a fine tooth comb or whatever. Permanent desalination plant is picked up in 461 and 466. .461 simply describes the situation. Secretary of State notes the concerns of applicants, agreed there would need to be an assessment. So he's not doing the exercise that my Lord Justice Lewis is contemplating here or anywhere. It's not.
That's not what I was suggesting.
No.
Don't let me stop you.
I'm sorry if I misunderstood. And then he's simply noting the applicant's position. So there's not really any conclusions in that paragraph. And then 466, in the unlikely event NWL can find no solution, it's confirmed it would seek to take forward its own solution, either by amending the DCO or something else, and there would then be an assessment at that stage. So I'm giving them the benefit of the doubt in saying that those paragraphs are part of the project analysis, but they're not explicitly so. So you could argue that the permanent desalination plant was erroneously not considered as part of the project. I'm giving them the benefit of the doubt in a non-fine-tooth comb reading of the decision and not saying that, but that doesn't provide the answer for the permanent desalination plant. Then really the rest of these 3 pages is the cumulative impacts bit, and actually 459 in a sense introduces that, and the rest are all broadly repetitive of it. 459, Secretary of State notes that in the light of the matters identified above, it's not possible for the applicant to provide, sorry, I'm in the wrong place, aren't I? 450, I'm completely wrong place. 450, I'm sorry. 450. I've misled myself. So 450 is where the Secretary of State deals with the cumulative impacts point, round 2. Secretary of State has considered the XA's view that even if the proposed development and the water supply are considered to be 2 separate projects, the cumulative effects assessed should be assessed at this stage. That's the XA's view. And then he has 2 reasons why not. As set out below, the Secretary of State considered the cumulative assessment of the proposed project and agrees with the applicant's assessment of the pipeline. The pipeline is not likely to give rise to any new effects, but that's only the pipeline. He then goes on, which is the more important point. In addition, the Secretary of State agrees with the applicant that the detailed potential environmental impacts, including effects associated with the permanent water supply, will be sufficiently assessed, and that the WRMP process is the appropriate means to do it. And then says it can't be done. So that's, again, only talking about WRMP process, but fundamentally saying it will be done later. And that's our para 74 and 75 habitats-related point. Again, that doesn't pick up the permanent water supply. That's come back to the two paragraphs we looked at before. If you now read them in the context of the assessment of cumulative impacts, you still don't get a better answer, we say.
Yes.
Lord, unless I can assist, I think that's probably, and I apologise for the time.
Not at all. Thank you. Anything? Thank you very much, Mr. Moore.
Thank you. Give you a moment to rearrange the furniture. Do you want to?
I should have said at the outset this morning that we received the housekeeping note from the second respondent. So we've done, say we, I have in fact done housekeeping, I'm not speaking for others, but thank you for the note. The authorities, the three authorities you added yesterday, Mr. Strawn, I've simply put at the front of the authority.
Thank you very much.
I can get it quickly. Yes.
My Lords, my Lady, I'm going to deal with the response in 4 parts, just to give you a brief overview, first of all, where I think we've got to. Secondly, just to come back to the legal framework. Third, to deal with the facts, including the decision itself. And then lastly, to cover the 2 grounds of appeal, or 2 grounds of challenge, which are under appeal. Although I suspect that would be a rather shorter, because in going through the authorities, many of the submissions will be foreshadowed.
Yes.
But just by way of overview, could I start by explaining where, at least so far as we're concerned, we see the current shape of the appeal. There is much greater clarity than was previously the case in our submission. And I say that for these 2 reasons. First of all, it was confirmed yesterday that the appellant now accepts that the relevant test that the court is engaged with, both for grounds 1 and 2, is Wednesbury review of the Secretary of State's decision, not a matter of law for the court to determine. So, for example, what constitutes the project for the purposes of assessment, or the adequacy of the cumulative assessment that was carried out and accepted by the Secretary of State. And, my Lord and my Lady, I would submit that that was not clear from the skeleton argument, or indeed the statement of facts and grounds. See paragraph 5. I'm not asking to turn it up now, but reference was made to Lord Justice Sales, as he then was, in Larkfleet, and then a submission made about that, and then the words, even if it's a Wednesbury review. So the case was clearly being put that this was a matter of law for the court to decide. But it is obviously helpful now that that's common ground. I'll come back to that in a moment. The second clarification that was given yesterday was an acceptance that it is permissible to defer the assessment of a project, or indeed the cumulative effects of a project, to a subsequent approval where it's not reasonably possible to assess those effects at an earlier stage. You'll recall that yesterday. In fact, I'm going to submit that the test of reasonable possibility may be too high, in the sense that the Court of Justice of the European Union has referred to, as you saw a moment ago, what is sufficiently identifiable. And I'll show you that in the Walloney case in a moment again. But it's obviously helpful clarification that in principle one can have a multi-stage process and defer consideration of effects where they're not reasonably possible to assess now or sufficiently identifiable. And if you put those 2 matters together, the 2 I call them concessions, but I don't need to be difficult about it. Clarifications, if one wants. If you put those two together, then of course it must be right that it's for the Secretary of State to make the judgment as to whether or not something is reasonably possible to assess or sufficiently identifiable. That itself requires a judgment which could only be challenged under Wednesbury grounds. That is, in my submission, the logic of those propositions. And so, putting that in the context of the decision the Secretary of State made, this was an application for a development consent order for the power station in a location which has already been identified in a national policy statement as a suitable location, one of 8, to meet the urgent need for nuclear energy for the nation. The court obviously hasn't had to consider, and I'm not inviting the court to do so now, but just to bear in mind, the vast range of considerations that did go into making a decision as to the acceptability of this development consent order for the project, which included non-potable water supply for the reactors. That was part of the project, was considered, and itself generated huge amounts of detailed information and a decision. The potable water supply, i.e. that part of the provision of water to the power station by the statutory undertaker, the water supplier, was not part of this project, wasn't identified as part of the project, and the Secretary of State concluded in the face of different views that it wasn't part of the project for the reasons we'll come to. But just whilst this is a case about Sizewell C, it's worth reminding oneself that that principle is applicable to most forms of development, be they residential, commercial, or any other use. Most developments do require potable water supply. I'm not saying all, but most do, certainly residential developments do, as do employment premises, for example.
Unless you've got a well in the back garden.
Indeed. And there are obviously exceptions, but for the vast majority of cases, you're talking about development that will come forward, but it's on the assumption that a different statutory undertaker will provide the necessary supply for that development to proceed. And that, often referred to as a utility provider, but is not limited to water, of course. It's electricity, sewerage, telecommunications, the things ordinarily covered by statutory undertakers under a different legislative regime, for which those statutory undertakers have their own powers. They have the power to build or to construct pipelines, to take way leads for electricity, to build sewerage facilities. They're given to them under different acts. I'll come to the Water Industry Act parts relevant to water, but it's important to realise this is applicable to a much wider range of utilities. And so there is nothing unusual at all about Sizewell C promoting a development consent order which rely upon the statutory undertaker, in this case NWL, that's just a peculiarity that it's Northumbrian Water, but they are the relevant statutory undertaker, providing in due course a water supply if the development's otherwise approved. And that would be indeed the case if you were proposing, as my Lord Justice Lewis posited yesterday, 500 houses, or indeed 10 houses, but any number of houses. That would be the same assumption. And it is, in my submission, commonplace for those projects to come forward. They may be subject to EIA or indeed HRA, but where the project is not taken to include the statutory undertaker's future supply to that facility. And that is why Mr Justice Holgate was entirely correct to consider the wider ramifications of the argument that's now being made. And there is nothing unusual in the arguments that Mr. Wolfe is making that he says are specific to Sizewell C, which would distinguish them from all those other forms of development. A water supply to 500 houses is a necessary part of those houses going ahead. They can't be occupied and used. But that doesn't make, in my submission, that part of the project to build the 500 houses. I don't need to go as far as that. I just need to convince the court that the Secretary of State was entitled to conclude rationally that that principle held good for Sizewell. We had actually dealt with the matter as actually being the correct decision in any event, if this was a question of law. And that principle applies to all other utilities as well. And so, of course, there has been particular focus on the potable water supply to Sizewell because of its location. Necessarily, there was consideration of what sort of pipeline, for example, would deliver that water supply to Sizewell. But it's important to emphasise, as identified in the decision, that pipeline itself would not be built by the Sizewell C developer. It would be built by the statutory undertaker, if that's what they choose to do, under their own powers. However, and just again, by way of overview, I'm sure I'll come to the detail, it's important to note that, and this is glossed over in all the paragraphs you were taken to in the decision letter, the applicant, the interested party now, did assess the provision of a 28-kilometre pipeline to connect to the water mains at Barsham. That assessment concluded there were no additional effects of concern, put that as neutral as possible, but no effects of concern on a cumulative basis. And the reasons were given and expressed by the Secretary of State for that conclusion are relatively straightforward. A pipeline for domestic or for potable water is a relatively small pipe. It's constructed in phases, and you lay the pipe, and therefore the disruption or effects on wildlife, ecology, whatever your SPA may be in this area, are going to be very limited, and they occur on a phased basis. That's all expressed in the decision by the Secretary of State in accepting that cumulative assessment made by the applicant.
You're going to come to the details, but put me out of my misery if you can, because I've been worried about this. It looks as if the thing that was assessed may not come to pass, the 28-kilometre pipeline, because I got the impression yesterday the end that goes into the water would have to be changed because the supply of the water source would have to change. So is it the possibility you'll still have that pipeline, but it goes somewhere slightly different at one end? Or is this now a dead duck?
No, my lord, the current state of affairs is that the pipeline is likely to remain.
Right.
What, and I'll show you this in the NWL letter.
Okay.
What the issue is that where the water going into the pipeline at that point, is there sufficient water at that point to, in effect, fill the pipe?
Yeah.
And that is what's under debate by the water undertaker. And as they point out in their letter, the NWL letter, there isn't, as things currently stand, sufficient water to say, well, we could supply all the houses, plus Sizewell, plus all the commercial development from that water resource zone. But we're going to come up with a solution which is a combination of demand management and supply measures. Demand management is encouraging people to use less water. In effect, you reduce the amount of water demand by various other means, and also by curing leaks in your system. You spend capital sums to reduce the amount of water that's leaked. That's one of the demand management side. the supply measures are, as set out in the NWL letter, it's in the supplementary bundle, any combination of things which may include reuse of effluent by treatment or reducing the amount of water used in water treatment processes. But in all of those measures, it doesn't necessarily mean you have to change the pipeline, because you can supply additional water to the point at which the pipeline starts. For example, and this is what's I don't want to give evidence, but what's currently in the plan, the Waste Resource Management Plan, is the provision of effluent treatment, which would then allow more water to be put back into the Waveney. So in effect, it's the same physical source, the location's the same, it's just dealing with how much water can be taken from the Waveney.
And you have more possible clean water in the river.
Exactly.
And that combination might mean for the same pipeline going to the same place and doing the same things, and that's one option. So that
Precisely.
option may or may not happen, but it's not something...
It may or may not happen, but there's still, as it happens, that's the likely position. Yes. But my lord, the point that you were asking about, namely a different pipeline, because that is contemplated in the Secretary of State's decision.
One, yeah.
Well, no, the Saxon one I think is the same one. It's the same one. Yes. But what the Secretary of State says, if it's necessary to change the pipeline, one that's already been assessed, then of course you would have to assess that. But no one is identifying, or has identified, in this case, these significant adverse effects being inevitable or indeed likely as a result of a different solution. So this isn't a case where it's said the solution will result in adverse effects to unknown SACs or SPAs. The solution that's preferred by everyone has been assessed, has no effects. If a different solution does eventuate, which is not currently planned, but if it does eventuate or proves to be necessary, then of course it will have to be assessed. But beyond that, we're into the realms of speculation. Because it's for the water undertaker, through a different statutory process, to test various options as to how it's going to deliver the additional water to meet its needs. And can I just put it in this context as well? That water undertaker is providing water to meet a vast range of different types of development in its water resources management plan for the next 5 years, of which Sizewell C is just one. Yes, it consumes a lot of water, but so does housing, so do other facilities. And it's under an obligation to plan for all of that under its statutory duties. I think there was a debate yesterday about attributing to Sizewell the amount of the infrastructure versus, and also the additional bits. That's an impossible task. One can identify, for example, a pipeline. That has been done. One can identify the amount of water that Sizewell is anticipated to need, and that's in the NWL letter that was sent to the Secretary of State. It's expressed as a cubic metre per, I think, day or year, I forget which. So one can do that, but to suggest that one could then disaggregate, so far as the water undertaker is concerned, any solution that they ultimately choose is an impossible task. So, for example, improving your reduction of leaks or anything of that kind is going to be very difficult. But if it were a point that one were capable of doing beyond identifying how much water is required, it would apply to every form of development. You can predict, for example, how much 500 houses is likely to need by way of potable water, or any form of business. So if this principle is to hold good, it would, as Mr Justice Holgate rightly recognised, hold good for all development. There's no real reason for distinguishing it because it's Sizewell. And so in my submission, and our submission, this conclusion that the Secretary of State's reached in this particular case isn't irrational, nor indeed is it surprising at all. Indeed, it's entirely consistent with what would ordinarily expect of the current development control system. And what I'm also going to submit, as the judge has identified, so far as habitat regulations assessment is concerned, whether one looks at this as two different projects or in terms of cumulative assessment, there is no objection in principle to the assessment of any potential effects occurring at a downstream, if I can put it that way, but probably a bad expression, but occurring at a subsequent stage when you know, you can sufficiently identify what your solution is. That's entirely acceptable under the HRA. And just to foreshadow the submission that was the subject of debate this morning, of course, that consent process will have to be undertaken compliantly with the habitat regulations assessment. And there is no presumption created by the grant of permission or the development consent for Sizewell will mean that the water solution has to be approved. I think it was put as overwhelmingly incredible that it would not be refused. My lady, that is completely contrary to the statutory system, and indeed the principle expressed in Larkfleet paragraph 19, and more obviously the direct application of the habitat regulations assessment. If such a future decision were made on that basis, it would be itself susceptible to challenge on the basis that that is simply unlawful.
You said Larkfleet, do you mean Forest of Dean?
I'm sorry, Forest of Dean, paragraph 19.
Yeah,
I'm so sorry.
I think that's
absolutely right.
The one piece of the jigsaw that I'm sure the other side would say you haven't assessed is, I think at one level what they might be saying is, look, if you had waited and you knew it wasn't pipeline A, it was pipeline B, or worse, you'd gone to the default position of desalination, there might come a stage where, looking back, you could see that the combination of the power station and the thing that ultimately was settled upon as the water supply solution would together have given greater adverse environmental impacts than was realised. And they seem to be saying, by different routes, that therefore you can't or shouldn't, as a matter of law it seems, go ahead with a power station, because there may come a time when you have underestimated the adverse environmental impacts.
Well, I think that is the way.
And
the
case.
answer to that? But the answer to that is, in my submission, quite simple. What the Secretary of State has assessed and permitted, and only permitted, is that part of the power station, which actually is everything that was applied for, on its own terms. And the effects of that, if it's constructed in that way, are acceptable. To give you a particular example of that, one of the features, I think my then friend referred to this, is that in constructing Sizewell C, there will be some temporary construction effects on Marsh Harrier, hence the HRA assessment and the assessment of Europe, because that effect couldn't be fully mitigated. That, however, the decision that's been made is that package is acceptable as a proposition. The water if the water supply in due course that NWL comes forward with, contrary to all expectation, I should say, because I'm going to refer you to that, this has to be looked at in the context of the facts here, but were to involve some adverse effects, it's going to be either as a result of the solution of what goes in somewhere else into the pipe, or because a new pipeline is proposed, although it's difficult to see why that new pipeline is going to create adverse effects, but let's assume hypothetically it would. At that point, the effects of allowing that adverse consequence for whatever protected sites have to be properly assessed at the time, and it wouldn't be permitted to go ahead if the balance of the adverse effects are such that you can't be justified, whether on European grounds or...
That's for the water supply, but Mr Wolfe is saying you've never even granted the power station in the first place if you'd known that that was it. If you'd known that the only pipeline you had went straight through a Ramsar site, and you had the upsets of the marsh harriers doing construction and possibly operation, if you'd had those two things together, he's saying you wouldn't know. That's his real point, I think.
Well, what the habitat regulations assessment is concerned with is harm to the European site. This is the entire case is based around habitat regulations assessment. That harm cannot occur in an unacceptable way if the habitat regulations assessment...
Just to test this, if I may,
yeah.
To take the marsh harrier, suppose an assessment is undertaken at stage 1, power station,
yes,
consent stage. Then along comes the proposal for water supply later on, and that has to be assessed, that's common ground. A cumulative assessment is appropriate, because, not least because it is common ground and is the fact that the power station can't operate without the water supply, so there is clearly a requirement for a cumulative assessment. If it turns out that when that assessment is undertaken, that the effects on the marsh harrier previously assessed would now be different, either because, well, assuming that they might be different, simply because they were different.
yes.
But also there were or there weren't other effects on its habitat. That would all have to be subsumed in the cumulative assessment at that stage.
Absolutely.
Together with any other effects attributable to the water supply.
Absolutely. And that's the nature of, if I can put it, a deferred, it's not really deferred, but a subsequent consent.
Yeah.
Before that situation is allowed to occur, that assessment will itself have to be cumulative, right, and look at what's already been consented, and indeed anything else that may have come into the picture at a future stage, if there were anything.
Mr Wolfe's point is that's all too late, because if all of that had been taken into account at one go, at stage 1, if you like, rather than put down the line for a cumulative assessment at a later stage, he says it is not inconceivable. He doesn't need to go any higher than that. It's acknowledged by the experts that it might tip the planning balance. He says that's as far as he needs to go, and if it might have tipped the planning balance, then it shouldn't be kicked down the line. I'm putting it much less elegantly than Mr Wolfe has, but that's basically his point.
Well, I can deal with that. First of all, the HRA assessment at that point would be preventing the harm that's being the additional harm that's being identified. It could not occur unless it were justified. So that additional harm simply could not occur if the habitat regulations assessment is being properly applied. As to whether or not one would have granted, in hindsight, the DCO in its current form, in my submission, that's highly retrospective, speculative, but it's addressed by this. The habitat regulations assessment and the whole principle of habitat regulations assessment is not based upon a system which doesn't allow for a pragmatic advancement of development. And what I mean by that, and this is perhaps best illustrated by the national policy statement I want to show you in a moment, there is already, and there has already been a decision taken as a matter of habitat regulations assessment to approve a national policy statement that identifies Sizewell as a suitable location for a nuclear power station. Indeed, it's been justified on European grounds. And that's one of 8 sites identified in the National Policy Statement. And as I'll show you, the Planning Act means that if anyone wanted to challenge that, they should have challenged it when it was made. That assessment was made based on application of the Habitat Regulations Assessment, even though the precise effects of any development coming forward would not be known. And maybe, ultimately, if your effects were so bad at the development consent stage, you might not have designated it as a suitable site in the National Policy Statement. But all the Habitat Regulations Assessment permits is for you to make a decision at this stage based on effects which are sufficiently identifiable. Yes, it's conceivably the case that as you go down the consent route, you learn something which you didn't anticipate, which means, well, if I'd known that, maybe I wouldn't have designated it as part of the National Policy Statement earlier, if I'd known there was something so fundamental. But that doesn't matter.
So the designator had a habitat assessment done at the time, and when they picked these 8,
yes,
I'm
going to show you that.
What the 8 would affect, and they decided, yep, we need nuclear power, and that outweighs. So that's been done. So that was stage 1. In fact, stage 2.
We're already past stage 1.
Stage 3 will be the water supply.
We're past stage 1. Stage 1. Of course, the details of the development were not known, and it was always recognised there would be a further habitat regulations assessment, and indeed many other assessments.
That's how it works, as I
But that's
understand
exactly how it works.
It's exactly how it works. You start with what you know at the early stage, which will be the big picture.
Correct.
And the general understanding of the birdlands and so forth. Then you look at the specific details of the proposed project, and there may be certain aspects of that that will impact on a particular site more than was anticipated at stage 1, because you've now got more detail. So you do an assessment there and you do the balancing act there. Exactly. Then you get to stage 3, as my lord terms it, and you carry out the exercise again.
Absolutely.
And the fact that you might have reached a different conclusion in the light of hindsight had you known then what you know now is neither here nor there, you say.
Exactly right, my lady.
But what about Europe at the development consent stage, stage 2? I think the argument is that there's a kind of self-fulfillment going on at that point, because if there are indeed unacceptable cumulative effects, and a cumulative assessment has been properly carried out and finds them, Mr. Wolfe says the difficulty then is consent's already been granted for the power station, and that is an element in the European assessment.
Well, that's the foot in the door where it's put. My lord,
What's
the answer to that is the foot. There's more than a foot in the door. The door's already open through the National Policy Statement. That establishes the in principle suitability of this location after carrying out a habitat regulations assessment.
It doesn't prevent. I'm so sorry.
Sorry.
No, you carry on. I'm sorry.
So talking about this as a foot in the door, in my submission, is completely wrong. And in fact, that's not what Lord Justice Sales was getting at. He was talking about people disaggregating the development in a way which would allow you to get a foot in the door. Here, the National Policy Statement already opens the door, as a result of which, and I want to show you the statutory reasons for that, it stimulates investment, confidence that in principle there's a policy that allows someone to spend an awful lot of money pursuing the details of a scheme. That's the door that's already open. Insofar as there's a subsequent habitat regulation assessment that demonstrates that, contrary to what you thought, there is an adverse effect which is not justifiable, that will be the end of the matter. You'll have to stop. The submission that the Europe judgment changes, in my submission, is wrong. There is already an Europe argument in favour of A, nuclear power, and B, this site, because it's already expressed in the National Policy Statement. And so one has to be very careful indeed thinking about in the future, if there were a water supply solution that has an adverse effect, and there weren't an alternative, bringing in Europe at that stage, it would be perfectly legitimate to bring in the Europe of delivering nuclear power at Sizewell in this location as part of the national policy statement, because that already exists as part of the planning balance. It's only suggesting that it, in some way, granting the development consent to allow this stage to go ahead, somehow distorts or skews it. And in my submission, there's no basis for saying that.
I think Mr. Wolf is effectively saying you have another Europe exercise at development consent stage, so that notwithstanding that it's already, as it were, built into the national policy statement stage of the whole exercise, it does become, as it were, re-engaged in the development consent context, and its value can be had again, and that is because, says Mr. Wolf, you've already granted consent for the power station, and the argument is therefore available. If you don't grant this water supply proposal its consent, the power station, with all the things you say about it, the importance of it in the national context, etc., that will be frustrated if we don't grant consent at this point. And I think that, unless I've misunderstood the argument, that's the mischief, that's the real mischief at the core of this case, says Mr. Wolf. And I think really we're striving for an answer to that.
My Lord, as I said, that the answer lies in the stage process. I hope I'll answer in this way. There is at the DCO that we've got before us, there was an Europe assessment in respect of the Marsh Harrier, and it was said that that effect is justified by the imperative reasons of public interest of providing nuclear power in this location, amongst other things. So that Europe exercise has happened under this DCO. And of course, in that respect, one's relying upon principles in the national policy statement. But it was perfectly acceptable for the national policy statement to designate A, nuclear power, and B, Sizewell as a suitable location, without distorting the future Europe assessment that would come at the later stage, even though, of course, one could, no doubt the developer might have said, well, we've spent all this money on the basis of the national policy statement promoting a DCO, that must be part of the Europe assessment. No, you still have to justify at the DCO stage, is it Europe? The same principle will apply for an Europe assessment for the water supply. At that stage, the Europe argument will be the same. It can legitimately take into account the benefits of nuclear power and nuclear power in this location, because that's in the national policy statement. But as the judge pointed out, and we fully accept, it will also have to balance all of the harms that are being identified at that stage.
So
there isn't any...
This pipeline goes through the second Marsh Harrier site in Suffolk. Yes, we want a power station, terribly good thing, but this isn't just affecting a Marsh Harrier site. This is the second one we lose, and we can't lose the second.
And the balance has now shifted. The balance now shifts because the new harm that's being identified, taken with cumulatively the harm that's already been identified, now means the judgment is you can't justify it. I mean, in a sense, that would be the same if the decision were being taken now. If you knew of such a pipeline, you'd still be carrying out the same exercise. It's just postponing it to the point at which you know what effects you're actually going to have. You don't know that there aren't going to be any.
You know the effect of one Marsh Harrier site is unfortunate but acceptable.
Yes.
What the cumulative assessment would have shown, even if done earlier, would you can't lose two because you only got a limited number.
Precisely, and that's what will stop the power station ever operating.
Yes, well, that depends on the water supply consent being properly considered and if appropriate, refused.
Yes, my lord. But the assumption that it won't be properly operated is, in my submission, a completely flawed one. And the assumption that the Europe argument is somehow skewed by the grant of the DCO, no. The Europe argument will be as it is at the point that you know the full effects, if they are different to the ones that were at the DCO stage and the cumulative consequences are such, then the assumption would be the water supply would be refused, just as
It
it
only
would.
makes sense if they're different, because if they're the same, they've already been assessed.
Yes, well, absolutely. But the reason I said that is because there's been a repeated assumption that the water supply solutions will have adverse impacts which haven't been assessed.
Yeah.
That's not right. The actual assessment that's been carried out includes a pipeline that has been assessed. It's only if that moves, and it's only if an adverse effect elsewhere as to what you do to get the water changes and results in an adverse effect that you then have the scenario. But in those circumstances,
they may not be able to do that at their point, and they may end up having to put some enormous desalination plant right next door, upsetting even more marsh harriers and other species. Is their point?
Well, that's a slightly different point in relation, and I want to deal with that on the evidence as to whether or not the Secretary of State was required to treat the permanent desalination plant as either part of the project or cumulatively assess it as if it were going to happen. And in my submission, absolutely not. The applicant wasn't proposing permanent desalination. Indeed, it only arose when the Secretary of State asked the question. Not something the applicant has ever proposed. When the applicant raised it, they said it's possible, you can do it, but you would need to do a full assessment of it, although they didn't anticipate any adverse effects, contrary to what Mr. Wolf is saying. The claimant, the appellant, in their submissions in response, said it was totally unacceptable with permanent desalination plant. So everyone, apart from Secretary of State who's asked the question, was saying we're not pursuing this as our part of this project or proposal. And in those circumstances, in my submission, and I only need to go as far as say it's rational, it's perfectly rational for the Secretary of State to say, I'm not going to treat that as part of this proposal. If, and the word if is repeatedly said, and if one ever gets to that situation where it becomes a reality, then it will have to be assessed. And that principle I've just explained would apply to that stage. It would require the powers to build it, because they're not in the DCO now, so you need to take powers to build it. You would need to do the assessment work as to what consequences it had, and those would have to be cumulative, just as a pipeline would be cumulative. And at that point, if it had adverse effects, then the same arguments I've just made would apply. You would have to deal with it on its merits.
I come back to the point, fairly simple point, which is what on earth is to be achieved by carrying out an assessment of this hypothetical desalination plant, which nobody wants and which is the most fallback option, when everybody is assuming that the statutory utility provider is going to provide the solution.
Well, my lady,
because it serves no useful purpose.
Yeah. And my lady, I'm not dissenting at all from that characterisation, but can I just convert it into the legal analysis of the challenge here?
Yeah.
Is the Secretary of State rationally entitled to come to the view that he did, that you shouldn't treat that as part of the project and you shouldn't cumulatively assess it because no one's pursuing it? Answer, yes, it's well within the range of rational responses. It might be the response many people would have, but I don't need to go so far as that.
The last question on this, and I'll let you get on. The logic of all of this could result in this situation. Every solution for the water supply is ruled out because the cumulative effect is too much. You can't lose any more than you've already lost on the water at the power station. Theoretically, you could have a power station gleaming and incapable of ever being used and operated because you can't get a cumulatively assessed water supply. And you say, if that happens, which is, I'm sure we'll say is unlikely, that is just the working out of the system. At each stage, you've taken a decision on the information available for the harm from that. If you get to a stage where you don't have an operational power station, which you think is unlikely, that doesn't mean you rejig everything and say, well, you've got to get something earlier on or not approve until you've got it. Is that it?
My Lord's absolutely right. That is the logical consequence of what I'm saying. And in my submission, no worse for it. But the reason, the added important element to this is what lens is the court reviewing the Secretary of State's decision as to that possibility? It's one of rationality. Could the Secretary of State make the decision he did with that remote possibility on the horizon? Answer emphatically yes, because no one was contemplating in reality, based on the evidence, that being a likely outcome.
Well,
and indeed,
it's part of Mr. Wolf's case that it's a vanishingly unlikely outcome.
Well, exactly.
His case on ground two is it's stacked the other way, because once you get a development consent for the power station, you're never going to, in reality, he says, find anybody refusing consent for the water supply.
Well, my lady, I've already dealt with that in saying the logic of how one looks at it. But what I was trying to bring in there is the evidence before the Secretary of State, which he is taking into account and making his decision, as set out in the decision letter, because that's how the rationality assessment needs to be examined. On the evidence before the Secretary of State is the legally logical conclusion of a possibility, one that makes his decision irrational? Absolutely not, because he had identified cumulative assessment of a pipeline to a location which doesn't cause any adverse effects. NWL pursuing options to meet the water, indeed they're putting it in their water resource management plan regardless of the consent. So they're planning for this even though they don't know the outcome of this decision. Those solutions don't necessarily, and no one's identified any adverse effects coming from them. There isn't any presupposition that there are adverse effects of that kind. And even if they were, in brackets we don't know, there's no suggestion that they would be so dire that it would lead to the conclusion that you couldn't operate. But what the Secretary...
pipeline, you're planning for it as part of your water supply. There's a default position of the desalination project, all of which will mean that something will be there. The prospect of you having inflicted these environmental harms in vain, you say, is something that's to be assessed by rationality, and it can't be said to be irrational if the Secretary of State says, I've looked at everything, something's going to happen here, and it will be assessed.
Yes, but that's absolutely right. But the logical legal consequence of what your Lordship put to me, and I've accepted, is important, because, of course, that's the thing that ensures that the adverse impact to the habitats could never occur if the judgment were such that it wasn't a tolerable one. Yeah. Because one of the things identified by the Secretary of State in his decision, and he satisfied himself of, was to operate this facility, you need a nuclear site license, and the ONR would not give you a nuclear site license if you don't have a potable water supply. Yeah. There's another control mechanism. In the words of the Habitat Regulations Assessment, a consent is required before this project can actually ever generate or be commissioned for nuclear power. So that logical point is important. That's the control valve. But the steps as to the rationality of that ever occurring are all the evidence before the Secretary of State, which he weighed in the way he's entitled to as a decision maker.
But your fundamental point is you can't, in a process like this, require 100% certainty about all potential aspects before you grant the DCO for the plant.
Precisely, and my Lord, we've made this point in our skeleton. That point was, I think it was Mr Justice Burnett, as he then was, described as these regulations not being there to create sclerosis of the system. And of course, the objectors here would like to stop it in its tracks, hence why we're all here. But the Habitat Regulations Assessment is not intended to be used in that way. Its intention is to prevent harm, unacceptable harm. That mechanism is secured in this process. There isn't 100% certainty in every stage of the process, just as there wasn't when the national policy statement was articulated. But that doesn't matter. So I've gone...
Is that your overview? No, I just want to. I mean, obviously.
Yes, no, that's right. Can I then? I'll move on to the legal principles.
Well, I just want to be clear that that's what we're doing now.
Yes.
Nothing to add to the overview.
No, my lord.
Right. So, legal framework.
So the legal framework, I'll try and take relatively shortly. There are 2 points on the Planning Act, which you'll find in the bundle of authorities at tab 2. As it happens, I think you've only got section 5 of the Planning Act in your bundles.
Yeah.
And many of our submissions, and indeed some of the judges' analysis, relate to the wider Planning Act. But that, I think, won't matter because the parts of the statutory framework of importance are derived from the Friends of the Earth case in the Supreme Court, which you do have in your bundles. I'll just give you the reference to the Planning Act, actually. It's in tab 2.
Yeah.
And section 5 is there identifying the process necessary for a national policy statement to be designated. And it's a different, as your lordships and ladyship will be aware, it's a different process to a normal national policy. It's approved by Parliament. It goes through consultation. And it can't be challenged other than by way of judicial review within a certain time period. And the significance of that is, and the reason for it is explained by the Supreme Court in Friends of the Earth case, which you do have in your bundles at tab 21. It's really the section of the judgment beginning at paragraph 19. It's the joint judgment of Lord Hodge and Lord Sales. Paragraph 19 through to paragraph 38. They refer to the objects of introducing the Planning Act system, and in the white paper that's explained in paragraph, or quoted from in paragraph 20. And the reason I draw that out, sorry, I was going to take that at speed, but this is important to the sclerosis of the system that I was referring to. The national policy statement designation is intended to accelerate the system and avoid debate about the principle, the national policy principle of certain types of infrastructure. And as identified in the white paper, to permit investment to be made to bring forward these projects, nationally important projects, in a way that the planning system inhibited previously. And that's explained and considered in paragraph 19 onwards. And the statutory mechanism, in brief, and I'll leave the court to consider those paragraphs, that's paragraph 38, but the statutory mechanism of designation of a national policy statement and then a time limit for challenging that policy by way of judicial review, and then if in the absence of challenge, it remaining designated national policy, and section 106 of the Planning Act, which allows you to disregard challenges to the national policy in a DCO process, is all important because it's there to try and facilitate the delivery of these projects where there's an identified need. And that applies with particular potency in a case of this kind, where, of course, the nuclear power station requires some time to be constructed. The potable water supply that we're considering is actually delivered by another statutory undertaker at their pace, if I can put it in that way, but they have their own statutory processes to follow. And it's completely inimical to the situation for any development, but particularly the national infrastructure under the Planning Act, to be suggesting that somehow consents necessarily have to be held up because of another statutory undertaker's supply of water, electricity, whatever it may be, until they've confirmed their particular project. That would just be, in my submission, completely contrary to that whole structure. The same point could be applied to normal development control, but it has this particular resonance here. And then, in that context, I just wanted to make clear that the two national policy statements with which the Secretary of State was dealing here are NPS EN1 and NPS EN6. You have extracts from them in the bundle at tab 28.
That's called, sorry, that's this bundle.
Of the bundle of authorities. EN1 is at tab 28, and then EN6 is at tab 29. You don't have the whole documents, and some additional pages were inserted by my learned friend. But can I just make some, I haven't got time to go through the detail of it, but just make some very simple points about it.
No.
NPS EN1 identifies as a matter of national policy, see page 764, a need for all types of energy infrastructure are specified, and the urgency of that need. And at 765, paragraph 3.5, the role of nuclear electricity generation. And
so we're looking at, do you want us to look at this?
I'm just flagging it up, my lord, but 3.5, you'll see 3.5.1, that nuclear energy is considered to be, as a matter of national policy, part of the nation's ability to deliver on aspirations of climate change. Yeah. It's a fundamental part of the strategy. And of course, not only is this court not debating the merits of that strategy, but the whole Planning Act designation means that it's not open for debate, even at a DCO. This is just what the government's policy is.
Having been assessed.
Having been assessed, as I'll come to, yes. The three, yes, I ought to just take you back. Yes, it's not in this section. Yes, sorry, 5.3 then provides further explanation of nuclear energy. I don't need the court to read all of that. 3.5.5 explains how it will work as part of an electricity mix. And then 3.5.9 deals with the urgency of its delivery and brings in policy EN6. You see that in the middle part of 3.5.9. And 3.5.10, set within the context of that urgency, explains that for those reasons the government's gone on to look at identifying sites for delivery of these power stations. 3.5.10. And my lord, my lady will be aware that, of course, the Section 5 allows you not just to set a policy, but in certain cases to set locations, suitable locations for developments. One of the things identified in Section 5 that the policy can do. And that's precisely what this policy does. And we can then turn to 769. As part of that, alternatives were considered. There was previously a ground of challenge as to the alternatives to nuclear power in this case, which was rejected by judges, not pursued. But there has been consideration of alternatives in setting this policy approach. And then if I can take the court to tab 28, the relevant parts of EN6, this is where one has the identification of the relevant sites. But if you turn to page 773, paragraph 1.7, there's been an appraisal of sustainability appraisal of the national policy statement.
This is tab 29, I think.
Tab 29, yes, sorry.
Oh,
I'm sorry, did I say 28? Apologies.
Doesn't matter.
It's page 773 at the bottom one.
Yeah. And
you can see that that has included appraisal of the assessment of the sites 1.7.3 and then 1.7.4, including HRA assessment of the possible adverse effects on nature conservation of those sites.
There's something there called the Nuclear Habitats Regulations Assessment. Oh, so it's the same
That's
habitats regulation. It's just the assessment is called nuclear. There's nothing special about regulation.
No, I think it's called nuclear to describe the fact that it's been carried out for this nuclear.
Right, okay. There's not a set of regs with this.
No, there's not a different set. It's just the name given to the document.
Yeah.
And 1.8 explains interaction with the Habitats Directive. It's accepted that this is effectively a plan or project requiring assessment. And so the reason I show this is to make good the point, we're not at stage 1. Now, of course, for these purposes, if you can carry on in the document, Assessment Principles, Part 2, sets out the approach to assessing particular development proposals as they come forward. And I'm not suggesting at all, and it didn't happen in this case, there isn't a need to then assess the development project for all of its various effects to check their acceptability. And that, of course, includes the habitat regulations assessment that's done for a particular project, as here. But it's done within that context. And it explains, for example, at 2.5, the way in which one does need to or not need to look at alternatives.
2.5 or
2.5 of EN6, page 778.
all right.
And then on page 779, you have the list of potentially suitable sites that's emerged from this process, which of course includes Sizewell as one. And 4.2, it once again confirms the HRA assessment that's been done for that list of potential suitable sites. 4.2.2, third bullet point. And then just to complete the picture, because it was recognised that developing these 8 sites would potentially have adverse effects on various, because of their locations, there was an EROPI assessment justifying the policy. And that's contained in Annex A to EN6. Beginning at page 781. And there's quite a lot of detail there, but it explains why they consider it necessary for potential sites to be listed, identified in the policy, notwithstanding those adverse effects. See A4.1 on page 787. And the conclusion at 790, page 790, A6.6, the government satisfies that there are EROPI in making these 8 sites available as potential sites for development, subject to the IPC, from that which now reads Secretary of State, detailed consideration of the proposals for any site on which an application comes forward. So it's those 2 parts. Yes, in principle, potential suitability of these sites, but yes, of course, you'll need to do a further assessment in due course.
The reference there was?
For A.6.6 on page 790.
A.6.6.
Yeah, it's
Our pages are one ahead. When you say 790, it's 791 for us, right? But don't worry.
I'm so
You've been
sorry.
giving us a paragraph.
I think I'm missing. I think I had the earlier bundle that I've.
Don't worry. Just let you know.
I'll try and add
One.
one.
And then it'll go wrong for another reason. But don't worry.
So I'm very sorry about that. Right. So and that's all I want to draw the court's attention in the policy statement.
Right.
That is why in my submission, when one comes to talk about a foot in the door, the reason that I've said this is the policy that opens the door. It doesn't mean the door is always open. It can be shut again in the event of a more detailed assessment showing the particular proposal doesn't work. But the principle both of nuclear energy, its urgency, and the potential suitability of a site at Sizewell has already been the subject of an HRA and justification for ropey reasons, see the National Policy Statement. And none of that is under challenge. So those are the points I just wanted to make on the Planning Act and the Policy Statement. Can I then...
None of it is under challenge. Has there been any challenge at all?
I was trying to establish that to see whether there was a judicial review at the time. I don't believe there was, but I'm told. I mean, one doesn't always know if someone put a claim in and it was knocked out. It's unarguable.
Because they'd have had to be served with it.
Yet my client should know. I haven't asked them. That's true. I can find out.
Their mail, they should know.
I can find out. Or I can try and find out.
Well, if that's easy to do, yes.
But there certainly isn't any reported case where it was challenged.
No, well, I'm not conscious of any.
Yeah. So can I then turn to the Water Industry Act? Because the DCO process under the Planning Act, of course, doesn't of itself trespass on the existence of other regulatory regimes. And one of the points made in the NPS is, and it's in the Secretary of State's decision in the paragraphs you identified, you should duplicate controls elsewhere, in broad terms. So, for example, environmental permitting, there's still a requirement to seek permits and those controls, other regulatory legislation, and in our submission, the Water Industry Act and what's going on separately is not trumped or in any way supplanted by the Planning Act. The Water Industry Act is at Bundle Authorities tab 1.
Yes.
And you were taken to some of these provisions already. I don't need to, and Mr Justice Holgate's judgment has identified in our submission the right parts. Section 37 is the general duty to maintain a water supply system on page, I think I've got this right, 8. And there you can see a statutory duty which is about the provision of supplies of water. There's similar provisions in relation to sewerage in different parts of the Act, as there are for electricity, etc., in another Act. But here you can see a duty of supply which is controlled or regulated under Section 18. And in order to comply with that duty, the statutory undertaker has to prepare, publish, and maintain a water resources management plan, see Section 37A on page 9. And it has to review its plan, as pointed out yesterday, for example, in relation to material change of circumstances, but it also has to do it on a 5-year basis, see Section 37A6, subsection 6. And so you often see them in 5-year cycles.
No.
And significantly, in my submission, Section 37B sets out a statutory process for the formulation of these plans. And without wearying the court with all of the detail of that, there is indeed a statutory process supplemented by regulations by which the statutory undertaker produces a draft plan, it's subject to representations, and then potential inquiry is held. See subsection 6 of 37B. And the court would no doubt see the echo between the development plan process. But it's happening in a different context. This is about the supply of water. You have the ability to make representations. The other important feature about this is it's subject to its own strategic environmental assessment process. and habitat regulations assessment process. It's said that that's not in dispute, but it can't be in dispute because the regulations and the guidance make clear that both apply, but hence why anything that comes forward in terms of a water supply connection for this proposal, not only would it, if it requires development consent in the sense of a planning permission, go through that process, as part of the plan, the delivery of the plan, it's going to have to go through approval process in that way.
Where is the source of that duty?
There are two sources. The Environmental Assessment of Plans and Programs Regulations 2004, Regulation 5.
Where are you reading from?
I'm just giving the answer to your lord.
Oh, no, sorry, I wondered if you were reading from
No,
provision.
it's not in the. You'd have to look at the regulations separately. Yeah. We haven't wearied you with all.
Is this in your skeleton argument?
I think it's the proposition that they're governed by. I'm not sure it is.
I think you chose as a statutory process, but you don't reassure us by reference.
If you just, I'm sorry, just
No,
give us the references again, if you would.
I think actually that it may be the guidelines you put in. Yes.
Well, maybe this is a point that could be picked up by Mr. Philpott in due course.
Yes. Well, although I'm sorry, we haven't got all of the track down. But if I can flag it,
We're
SEA.
not doubting that it's correct. I mean, the whole case proceeds on that basis.
It does. So I think that's why no one's.
But I think it would be reassuring to know what the statutory or legislative source of the duty is.
My lord, certainly. The SEA regulations are the ones that deal with SEA. That's the Environmental Plans and Regulations 2004, and the habitat regulation, I think, just springs from Regulation 63 itself of the habitat regulations, which talks about a plan or project.
Yeah, so it comes simply through 63.
Exactly. There's no dispute that this is a plan for these purposes.
Yeah, a water resources management plan is a plan.
Indeed. The clue might be in the name, although there have been debates about that sort of thing in the past. But happily, that isn't in dispute here. And so Section 37B provides for that process. And importantly, so far as our submission is concerned, that involvement of representation, assessment, etc., is taking into account the wider functions of the water undertaker as how they choose to meet the demand that's placed on them in terms of future development, so housing, power stations, whatever else it may be. But there's a whole raft of considerations as to what they'll choose to do based on their site area. And I wasn't going to spend much time on this, but just to flag it up, page 21, I think still, I've got it right, is section 41, the duty to provide a supply for residential premises. And then section 55 on page 25 is for non-domestic purposes. As it happens, the power station has a requirement for both because of worker provision on site. And that's why you saw that the debate about section 41 was engaged, but they rolled that obligation, if I put it that way, into an agreement and coverage in the protected provisions that the section 55 duty would be fulfilled by way of separate agreement. But there is technically an obligation to provide the power station with supply under section 41 as well, but not for the non-domestic purposes.
Okay.
And my learned friends have made submissions about section 55 about funding. Of course, the non-domestic purposes, there isn't an obligation to supply if you can't effectively pay for it by the water undertaker. That's not an issue. And then the question of not compromising your other supply duties was also raised. That's not an issue in this case because NWL have already made it clear that they are committed to providing a supply to Sizewell and indeed promoting that necessary supply. It's in their demand calculations for their WRMP 2024, and that's in confirmation from NWL in their letter you were taken to yesterday in the supplementary bundle at page 75. And it's not, in fact, simply open to a water undertaker to refuse to provide a non-domestic supply on that ground, because there's another provision which says in the event of dispute, then it goes off to Ofwat to decide. Yeah. But in any event, here we're in the territory of a supply going to be
yes, all of that's common ground. Right.
The only other statutory provision which the judge below referred to is the Nuclear Installations Act of 1965. I'm content for your lordships to look at what the judge said at paragraph 41. But that, as I've mentioned a moment ago, is referred to in the Secretary of State's reasoning as the another control mechanism affecting the ability for this power station to proceed. There would be a need for a license for it to operate at all. That then brings me to the habitat regulations themselves. That's at tab 4. And there isn't, I don't think, any material dispute over the words on the page, plan or project. There isn't a dispute that the DCO was a project. And there isn't a dispute that the WRMP is a plan, whether or not the water supply beyond the pipeline requires any additional project, i.e. a intervention in the environment, will depend on what the solution is. But you can imagine, for example, that if it's purely demand management that were to control things, then there doesn't actually involve any development as such. But the plan itself, if that's going to rely on demand management, would require assessment in the way I've said. So taking that statutory framework and just applying what I understand the key legal principles from the case law relevant to this case, can I do that as quickly as I can?
Yes.
The first principle, first submission, there is no definition of a plan or project for the purposes of Regulation 63, but that need not trouble the court in this particular case because that's not what the dispute is over. And it's common ground that the Court of Justice has used the EIA directive definition of a plan or project in this context, i.e. in the context of habitat regulations. And the short point is, if a proposal is a project for the purposes of the EIA regulations, it will by default be a project for the purposes of the habitat regulations. The converse is not true, or sorry, if I put it in this way, the mere fact that something might not be a project for the EIA wouldn't necessarily exclude it from the HRA, but we don't need to get into that territory.
What is the CJEU authority?
And Waddensay at 20, paragraph 23 and 26 to 7, that's at bundle tab 27. And the Wallonie case, Inter-Environment Wallonie case, similarly tab 20 also repeats that proposition at paragraph 122 to 124.
The judge said, at paragraph 69,
Or 81.
no, 69, he said neither the Habitats regulations nor the EIA regulations define a project. Is that quite right?
I think it's not entirely accurate in the sense that, in the sense that there is a definition of a project in the EIA directive, which is identified in what I'm saying.
Yeah, so it's in the directive, it's not in the regulations, is that right?
Correct. Sorry, no, I think it's also. I think it's in the EIA regulations as well.
I'd be very surprised if it wasn't.
I'm pretty sure it is. I'll check that.
EIA development means.
Yeah. Yeah. I mean, that's the first sentence of 69 is not quite right, is it?
Before I accept
right.
that, can I? He might technically write that project's not defined because I think the EIA regulations may use different language in terms of development, but
yeah, I see.
so he could technically be right, but
I did say not quite right.
but my lord, the common ground about where we are so far as definition of project doesn't actually advance things at all in this case, because we're not concerned with is this a project within the meaning of the HRA. What we're concerned with is what constitutes the project for the assessment purposes. And there, I can be much shorter as a result of the clarification yesterday that question is for the Secretary of State to decide on a Wednesbury basis. I think it's probably wise for me to just say that I'm not proceeding merely on concession in that respect.
No.
There is good authority. There is the case of Khan that you looked at yesterday, tab 13, paragraphs 107 and 133 particularly is the conclusion of the judge in that case.
Is there a Court of Appeal authority?
And the Court of, well, that's Ashchurch. And those, it's a combination of paragraphs in my submission, 81, 83, 100 and 105. And the important point about the Ashchurch in my submission is that the court left the question as to whether or not there was a single project for the local authority to decide, notwithstanding that there was some clear indicators of whether it would be a rational conclusion to look at that. But it was fundamental that it was for the local authority to ask themselves the correct question. The vice in Ashchurch was the officer's report and the council just didn't address their minds.
It's terribly tempting to decide it, but we deliberately left it open.
But there was some there were some observations about it was difficult to see how a bridge to nowhere could be divorced.
As a matter of rationality, you wouldn't build a bridge
In the middle
there
of
was a
the
purpose for it, unless it was a mock Rialto.
And the facts as identified were stark in that respect. But the legal proposition Ashchurch's authority for, in my submission, is that it's a matter for Wednesbury rationality for the decision maker, as left by the Court of Appeal for the local authority to look at again, albeit they might be pushing at the rationality boundaries if they were to reach a different view. So that's the point.
Yeah, if one wanted to test the point, I suppose one would have to look at Lark Fleet, bearing in mind where that sits chronologically, if you like, in the progression of case law.
Well,
because I think there was a suggestion in Mr. Wolf's skeleton argument that there could be some doubt about this.
there was. He's removed that himself. And of course, Lark Fleet precedes Ashchurch and doesn't consider in the same way the application of Carn, Wingfield and then a conclusion reached by the Court of Appeal in that
Can't
case.
remember whether Carl was cited to us in Ashchurch, but we certainly looked at Larkfleet, and we certainly looked at some of the other cases.
Wingfield,
Wingfield,
which was Mr.
certainly.
Justice
We looked at all
Lang's.
of Wingfield,
Yes.
all the Wingfields we looked at.
Yes.
Is there
So,
an appeal in Ashchurch?
No, as far as I'm aware.
I'm not
think- I
aware
don't
of
think-
it.
I
they
asked
did.
that question with some trepidation.
I don't think there is.
Can I just, so that in our submission is, well, I had to be a little bit careful. I think I need to be strictly accurate here. I say it's authority for that proposition. In fact, it's an EIA case.
It's true.
So it's not an
HRA.
HRA case.
No.
But on the basis that for these purposes, the Court of Justice itself has treated these two concepts very similarly, it seems, therefore, it's at least, if not technically binding, it's highly persuasive, if I put it in that way.
Yes. Well, experience teaches one that one should take nothing for granted, ever.
But my lord, so I do need to correct myself in saying it's authority in that sense, because it's in here. But I just wanted to emphasise that conclusion that it's a matter of Wednesbury rationality, what constitutes the project, is entirely consistent with binding authority, both for EIA and HRA, that judgments in the assessment process are matters of Wednesbury rationality. So, for example, whether or not there are adverse effects, what the cumulative effects are, the adequacy of the assessment. There's binding authority for all of those propositions, and it's very difficult, therefore, to conceive of why an assessment of what constitutes a project, which is fact-specific, would be any different, because it all sits within the same legislation. And your lordship made the observation in the Wyatt case, at tab 24, paragraphs 9, brackets 1 to 3, that it's the competent authority that's deciding questions under the Habitat Regulations Assessment as to adverse effects, etc. In my submission, that's entirely consistent with the same principle, that the competent authority is deciding on whether or not the project has been correctly described.
Well, indeed, there's a passage in Friends of the Earth, I think, which goes in the same direction, roughly between 142 and 148, I think.
My lord, yes. So a lot of the judgment, I won't put it in that way, there's plenty of authority for the judgments under the assessment to be. There isn't, I don't think, a judgment that conclusively decides or the question of what a project is. But I strongly submit that, and this isn't in dispute anymore, that the same principles would apply.
Yeah.
Can I just, before we break, just make this observation? Once that point's accepted, then the question of rationality and material and immaterial considerations is governed by another set of authority, namely, which culminates again in the Friends of the Earth case, but includes the Sam Smith case in the Supreme Court, that what constitutes a material consideration itself is a matter of judgment for the relevant decision maker, unless it's a mandatory one because it's specified in law or in policy. Yeah. And so when one approaches the factors identified by Mrs. Justice Lang in the Wingfield case, and which Ashchurch Court was looking at and applying, those aren't mandatory material considerations in my submission. They are just...
She uses the phrase may.
May, indeed. And in my submission, that's exactly the way the Ashchurch Court approached it. Because they're not set out in policy, they're not set out in legislation, and they're not purporting to be an exhaustive or indeed definitive list of what has to be considered in any particular case.
They're possible points.
They're possible in factors to take into account. And the Sam Smith principle applies. The Secretary of State's not required to take into account considerations that the appellants say are material, and is not required to go through all of those factors and apply them in a particular way. The Secretary of State's rationality is assessed by reference to what factors he chose to take into account.
It may actually be my fault, but I couldn't quite grasp what was said to have been wrong or irrational in taking into account the very factors that were identified as potentially material factors in Wingfield.
No, my lady, in the judgment below, there's said to be various immaterial considerations which the judge dealt with. And in my submission, I stand by his analysis, because it's impossible to see why, for example, noting that the water supply is not defined as part of the project is somehow an irrelevant consideration. It's not definitive, as Ashchurch made clear. You can't. It's not a self-fulfilling definition that if you don't include it, it can't be part of the project. But it is plainly relevant that someone's not promoting it as a starting point for deciding whether it's part of the project. Because, of course, if it were specified, you'd be irrational for treating it as not part of the project. But the fact that it's not part of the project specified is at least a reasonable starting point, provided it's not treated as the end point. My Lord, I see the time. So
yes, indeed. Just as we look at the time, considering where we are, how much more time will you require to complete your 4 headings? Perhaps I should ask a different question.
How much time have I got?
Well, I think it may be coming towards that.
Yes.
Clearly, you and Mr. Philpott would have decided which of you is covering which ground. I think we must, working back, we're going to finish no later than 4:30, and that means finish the hearing, because it's been allotted a day and a half, and that will be a day and a half. We must allow time for a reply, and I think a reasonable time in the circumstances for that, subject to anything Mr. Wolfe may say, will be half an hour.
I'll speak to Mr. Philpott over the lunch adjournment, and we'll come to
that. Be right, and you can all 3 of you, as it were, or all 6, 7 of you, could perhaps discuss this. But if it is Mr. Wolfe starting his reply no later than 4, then you and Mr. Philpott have 2 hours.
I anticipate that would be enough, certainly, and will have to be, but I don't anticipate that being a problem. I think my learned friend indicated an hour and 15 minutes, and I wasn't actually anticipating much more than 45 minutes.
That gives you another 45 minutes.
That's exactly right.
All right, well, I don't want to start imposing a rigid timetable unless it's necessary, but of course always maintaining the fairness of the hearing, which is paramount. So can you, if you could all discuss that, we would be very grateful. Thank you very much. Then 2 o'clock, please.